welcome back. This is Newsfile. It's your most authoritative news analysis show. And like I intimated to you, since matters of allegations of wrongdoing in respect of causing financial loss or some sort of corruption have dominated the headlines this week, let's see how we will be able to manage with put two other similar matters together and deal with them quickly, so we can now move on to another bigger matter of causing financial loss to the state to the tune of over 2 billion. Now, you may be aware that at the NLA allegations have come up, and they are that very simple, that the NLA's head sister-in-law won a contract. Apparently, it's a contract for items that appear to have been broken in bits and pieces to beat the law, or in doing so, in trying to beat the law, actually breach the law. And so he says he doesn't see conflict of interest in it, and that the fact that you have a relation and you are at the top position doesn't mean that your relations cannot do business. Well, the people who are speaking on corruption say this is a very bad situation and he should not be heard to be suggesting that way. And also at Maslow, the procurement minister was invited to Parliament to answer questions, including how they came about a contract for supply of vehicles, 1,800 cars. That appears to have been done in a way that also smacks of some wrongdoing, but that contract was eventually terminated. So on the note of these two, once again, okay, maybe this time around, let me start with Yunus of Seni on the issue of the NLA matter. Let's see if we can take a listen quickly. As far as the NLA matter is concerned, we can listen to Mr. Osei Ameyao himself, and then we can also listen to Godfred Ewell, who spoke about the matter. So let's listen to Mr. Osei Ameyao and Godfred Ewell.
I don't preside over the processes of procurement, and people would just go around and make all preposterous allegations.
But if the beneficiary is your sister, whether or not you preside, you are the boss.
Beneficiaries, you know something? It's about time Ghanaians should stop all this hula baloo about who is a relative and who is not a relative and who is a friend. First and foremost, we must understand that if a corporation or a company that is a separate legal entity bids for a project competitively, and the competition is open, fair, equitable, transparent, and accountable, and somebody wins, I don't think it is a conflict. People don't even understand what conflict of interest means.
Did they prepare? Did they think about this? Did they plan to procure these items? What is the reason that all these items were not bulked together as one? And breaking the bulk is not necessarily wrong, but you need to convince the entity tender committee that for good reason you want to break bulk, because let's say you don't have suppliers in the system that do both rice and tomatoes or chicken and oil. But so you have to decide.
Right. So you heard the two men I had introduced to you earlier, and we understand that the matters of the things for the contracts were for the supply of items for end of year package, and you will see in situations where perfumed rice, there is 333 25 kg at 99,234 cedis. Then you had perfumed rice 343, that's 5 by 5, 25 kg. So that's how it's been broken down. That one to 99,470. 470. You had another package of perfume rice. That is 168, 50 kg. That one too was 99,120. Now, the total minerals and things that were broken down, you know, in bits, 11 different items, ended up a total figure of 579 plus thousand. Now the question is that if all of this had been put together, there would have been a certain process to be followed, and it was just done so as to beat that process. However, we are now being told that even the procurement law does not allow you to do this kind of thing. Mr. Miao says, look, we are just finding reasons where there are none to put him in trouble. Why are we doing that? Inus of Seni, why?
Oh, Mr. Honorable Ose Ameyao, Kofi Ose Ameyao, and let me disclose, he was my colleague in Parliament and my lawyer as well, when my client, when I represented him in the properties of his father. But in this particular case, because you are talking about your sister-in-law, there's a presumption that you are related to this woman in ways that can influence your judgment. And that's where the conflict of interest comes in.
He said he had nothing to do with it, despite the fact that you people say because of the position of the law, he's the head of the entity, you know, at his place.
So that's why I'm saying that it raises the question. To what extent did he influence that, knowing that his sister-in-law had put in a bid? To what extent? We don't know. Do we know? We don't know. 2, why did they bulk it? Why did they act that?
A very big bulk.
Why did they bulk the supply and made one person win the bulk? Is it due process? How much was involved? Was it done to be able to obviate the reach of the law?
They said there were about 3 of them. The sister-in-law was the lowest bidder.
Good. So these are, and did he disclose? He was not. He says he has nothing to do with it. In the conflict of interest provisions, we have the provisions that deal with disclosure. When you saw that your sister, and I can assume without admitting, if I put to test, that your sister would have discussed with you that he was interested in putting in a bid for.
She said she won it fair and square.
I'm not saying that she didn't work on fair basis. I'm saying, but that's your sister-in-law, and then you are the chief executive of NLA, and your sister is going to put in bid. She wouldn't tell you that, Mercy, I'm going to put in a bid at your place for the supply of consumables. And if your sister indeed told you, did you disclose at a meeting? Did you disclose to the tender committee that, look, this is my sister, but I have absolutely assessed her on her merits? Yes, conflict of Salah and the Attorney General. We can't carry conflict of interest provisions to the extreme because everybody is related to everybody in Ghana. But that's why we should have due process.
Bias.
Yeah, bias. That's why we should. And prejudice, bias, and all that. That's why we have. Again, we come back to the Constitution. So all that we are asking is, and who is a procurement specialist, I said, look, because of the way you did it, that is giving rise to these issues. So you shouldn't have done that way. That itself lends credence.
Because by the law, and as the head of the entity, he's allowed by the law, he's authorized to approve all contracts below the threshold of 100,000 cedis. So the claim is that this was clearly to
obviate that reach of the law. So why did they do that? So clearly, that's why I'm saying that there are questions. There are many questions and answers in this particular case. And to the extent that I myself will not be putting myself in the conflict of interest situation because he was my client, I will stop there. Okay. But the Maslock is really rotten. It's a rotten.
I thought like you have done very quick. We can do that
quickly and I cut to Maslock. Okay.
Yes. What do you say?
Counsel.
What do you say?
Okay. Before I came here, and by virtue of the fact that you gave us some research referrals to do, I got some documents, and I would want to situate all that I'm going to say on the evidence I have so far. It's a matter of fact that 3 companies put in a bid: JNL Ventures, Target Enterprise, and Ram's Kitchen. From the fact I got, Ram's Kitchen quoted 583,000. Target Enterprise 613,000. And JL Ventures 619,000. So obviously, if you are doing an evaluation and you want to look at value for money and you want to look at the least cost, Ram's Kitchen got this on merit, and that is not any financial loss to the state. It rather saved NLA money. So that must be put on record. 2, is Ram's Kitchen a registered entity? Yes.
It was at the time.
Hold on.
We were told that it's folded up.
Council,
after.
Council, I want
After supplying.
Yeah.
Council, I want to make a point.
Go ahead.
Again,
But
you are a lawyer.
Samson, you must be interested in who is behind
Those companies.
those 2 companies.
Exactly. You have to leave the veil there.
If you know something, tell me. I don't. Please go ahead.
Okay.
Okay.
JNL and Target, they are suggesting that something else is there. But please go ahead.
Oh, it's a realm of speculation,
Right.
and there's no problem.
Okay.
It suits their purpose, no problem. Now, you are a lawyer, and you should know that when somebody says that a company has folded up, it must be so done in law. Is it the case at the Registrar General? No. And it's an emphatic no.
Okay, so now they have said it. They haven't provided a
No,
document.
who has said it?
You are also
Who
saying
said-
it without
who
the
said-
document.
Who said? No, they said the company has folded up. Folded up, if you say the company has folded up, then it presupposes that you've been to Registrar General. You've written to them, there's an official response that this company is in official liquidation. This company is no more in existence. That is what would compel you to come out publicly to say that, yes, this company has folded up. And I'm telling you that there is no such evidence. Those who are coming out making that allegation has not put out this information with the document that at the Registrar General's Department, because today at the Registrar General's Department, you can just make an inquiry. I write to them all the time. When clients come to me, I go to them, they reply. Within a week, they respond to you. So is there any document? Because they furnished out, they put out there on the internet the registration certificate of Ram's Kitchen and all that. Is there a letter from the Registrar General's Department suggesting, without doubt, that this company has folded up?
Okay.
There's no such thing. Again, is it the case that Ram's Kitchen only registered to do business with NLA?
It registered in 2013,
Thank you.
June.
No, I'm not talking about even the Registrar General registration.
Okay.
I am talking about registration with NLA. My information is that Ram's Kitchen has been with NLA since 2015. They registered as a supplier at NLA
Okay.
in 2015.
We're being very quick about this. So your point is
So,
that, as far as you are concerned, it doesn't.
It's not that as far as I'm concerned, as far as the facts bear out, the facts are there to suggest that indeed there is no such thing as conflict of interest. It's another form of agenda setting in disguise. Two, that the entity, there were 3 other companies, and if my colleagues say that, look, the veil should be lifted, they should produce the evidence, come out and tell the whole world that JL Ventures is owned by Osaya Mayor. Target
no one has
Enterprise.
suggested that, though.
No. You were saying that they should lift the veil. That is what you
No
said.
one said that it's owned by.
Okay. Okay, so thank you. I think I can move on now because we have to do this quickly. He's made his point. I don't know how you see it. He says from the facts available and as he has canvassed, there's no need to suggest that there's any potential conflict of interest in this matter.
Okay. Why are thresholds set? Thresholds are set to enhance the control and decision-making process. So if thresholds are set that you have the authority to approve up to 100,000, and you decide that you are going to do, you are going to give end-of-year benefit, and you know the total comes up to 540.
There are different lots, different products, please.
This 540, you decide that each of them must stay within the 100,000 for you to approve. So in the sense,
he says different items,
those perfumed rice that you see in three different separations, they are different things. So don't put them together.
You can't.
Yes, I said. So when you are breaking it, you have to be clever about it. I mean, rice is right. There are suppliers in this country who can supply all types of perfumed rice in this country. So why the case in breaking them? So you broke them. Why is it that in your breaking, none of them exceeded your threshold? All of them.
All three of them are
stayed within your threshold. They're very close, 99.9 or something. Then you stay within the threshold
to be able to approve.
So at the end of the day, in one day, you are able to do an award of 540,000 completely outside of your control. But you go through a clever process so that you alone approve all. And when it turns out that it is your sister, you see, sometimes your sister-in-law or whatever-in-law, the issue is not about who eventually got it. The issue is the flawed process and the intent behind the process. So even if you did that process and it ended up with anybody at all, not even your sister-in-law, it will be worse. But even more rotten when it turns out to be your sister-in-law.
Some have suggested that what we should be looking at actually is not a question of potential conflict of interest, but Section 21(5) of the Public Procurement Act 2003, Act 663, it says that a procurement entity shall not divide a procurement order into parts or lower the value of a procurement order to avoid the application of the procedures for public procurement in this act.
Exactly so. So in the end, you have been able to actually sign off 540,000 when you don't have the mandate by cleverly thinking that you have done something smart. And all of them were done in one day. And for the same purpose. The purpose is to procure for end of service. Okay,
no,
I mean for
not end of service. What were the items? Where were the items? What were the items?
You are procuring purposely for end of year. And at the end of the day, what you have basically done.
What were the items?
Please, I think you are heckling him. Stop
it.
I can read back the items.
No, read it.
What you have basically done.
Do you mix rice with chicken?
What you have basically done is to circumvent the law.
Improper motive.
Is to circumvent the law in order to engage in this activity that is a violation of the Public Procurement Act. Whether or not you benefited directly or not is not even the question. And now it turns out that it is your sister-in-law. Clearly, if this country is to fight corruption, and we will make sure that the laws that we have passed. So one day somebody can sit there and break law until he gets 10 million and sign it off one day. 10 million. He breaks it on each of them. I have the energy to sign off 30 contracts.
In a day.
Just break them down. Each of them less than 100,000 and bring them. If there are 50 of them, 100 of them, I'll spend the whole day signing them off. And
okay,
in the
so
end,
he was asking for
the
other lot in the thing. I'd already mentioned the 3 perfume rice, different categories of them. Then you had tomatoes, tin tomatoes. You had malt drink. You had canned drink, malt drink, canned drink. Okay. Then you had mackerel.
And the malt was in bottles.
Then you had mackerel, and then canned beef.
Okay.
And then you had olive oil.
So if you put all the 3 rice together, you get to close to 300,000. Clearly, completely outside of his control.
No.
And he says that the rice, because they have been so described.
Push him to the fact.
Because they have been so described. Because the rice,
they are different.
Because the rice have been so differently described. They have different specifications. They must be separated.
No. This platform has a credibility, has a name. This is a platform of fact. Let's deal with that.
He insists that you cannot put the rights. He insists that you cannot put the rights together because they are different. They are different types. Okay, thank you.
Thank you.
I'm not marking. I'm not marking.
You are here to disrupt.
No, deal with the facts.
Yes, let's hear Kweku briefly. Let's hear Kweku briefly. And Kweku, you see, the other thing is that
for you,
is it fair?
Should go into this
Sorry,
immediately.
is it fair on those who are raising the allegation as they bring other things that something else that has happened as far as this man is concerned and say that he had taken a loan of sort or something from a contractor earlier and so on and so forth, which became an issue. So this is not difficult for him to do. As if we are ready to just, hang the man, prosecute him, so to speak.
Well, that would not be fair. We can deal with the issues, each on its own merit, and deal with it. So that would not be fair. But to be honest with you, I'm here to cite any documentation. But if you can help me, the contracts, you said there are 11.
Yes, 11 various lots.
Well, the same day she won.
Yes, same day.
She won all
everything.
Same day. Okay. See, it's seemingly untidy. I don't like the optics. I don't like what I see. I haven't said I have evidence to the effect that something went wrong. I have not judged, but it's seemingly untidy. Optically, I don't like it. And that is why I will support any call for further scrutiny.
So what are we going to do? We are going to be investigating all over the place.
Do we have the luxury of an alternative? We don't. If an allegation is made, however baseless and frivolous, and many of them are being made, subject it to scrutiny. That is the cure. Otherwise, perhaps the agenda, and in this case I'm speculating, of aggregating all these things together will come and bite you one day. Look, the best thing to do, the gentleman, Mr. Oseamea, if there are areas that he thinks are libelous, or if it's on radio and TV is slanderous, he also has options.
Right. Yeah.
So he can also, sometimes that's part of the cure as well. It's not always that the state should necessarily investigate. The individual who is being accused has the option also to cure the mischief by of course, it takes long sometimes, unfortunately for all of us. But I don't like it. It's untidy.
Okay, and as you have read the reports on the internet and elsewhere, it's like something happened at Boss, another has happened. This one too, they are referring to what has happened, and the report always says this apparent case of conflict of interest comes nearly 4 months after a Corruption Watch investigation found another case of conflict of interest involving the NLA director taking a personal loan of $60,000 from a supplier of the NLA, Kojo Graham's lot services. Kojo Graham, after a period of non-payment and denial of the receipt of the money by Oseamea, reported the matter to the Ghana Police Service.
That's another funny case. I'm aware of that case. I know some few things about it, but it is not a subject matter
of this.
now. Yeah.
Okay. But let me just, because I'm going into the Maslock matter.
Yes.
Okay. But let me just say clearly that you say you cited Section 21,
right?
And it looks like this activity violates Section 21. There must be a motive, even though you don't need to prove motive. But when you look at it, you will see the motive, the compelling motive why Section 21 was violated. And that's what
you are judging.
What's the compelling motive for you?
Huh?
What's the compelling motive?
Let the investigators go.
This one you miss you.
We will be right back to deal with the matters arising at Maslock. We'll be right back.